Good afternoon, everybody, and thank you so much for joining us. Today's broadcast is called the Legislative Roundup, and we've got Alec Bradford on the line. Alec, would you like to say hello to our listeners and introduce yourself?
Sure. Hi, everybody. My name is Alec Bradford. I'm the managing attorney of the San Diego office and also an equity partner. So we're going to be giving this presentation today. If you have any questions, you can go ahead and chat me during, and if it's something I can answer at that time, I'll go ahead and do it by the chat. If not, and we have any time at the end, I'll go ahead and answer them then. Back to you, John.
Oh, thank you much. And yeah, my name's John Kamen, and I'm located in BMB's Tarzana office. I've been an associate attorney here for 3 years now. And prior to that, I worked for WorkComp Central as their legal editor. And I also covered legislation in all 50 states for a number of years there. So naturally, one of the things we've always been keeping tabs on is the legislation and new rules and regs as those get approved by the state every year. So in short, today, here's what we're going to cover. We're going to take a look at bills that were signed by the governor in 2016. We'll also take a quick look at basically how well Senate Bill 863 is doing. After that, we will take a look at the formulary, which is supposed to be implemented on July 1st of 2017. We will also take a look at bills that were vetoed by the governor. But even though they were vetoed and not passed this year, those are probably going to pop up again in future legislative sessions. So here's a list of bills that were signed by the governor. Most of these were signed in late September of last year, and most of these became effective on January 1st of this year. Senate Bill 1160 is the big bill you've heard of. Assembly Bill 2503 states that RFAs go directly to the adjuster. AB 1244 pertains to suspension of physicians. Senate Bill 482 deals with doctors having to check the cures database before prescribing medication. AB 2883 deals with exemptions of executives from insurance policies. And lastly, we have Assembly Bill 2710, which deals with how carriers can charge employers SEIGA assessments. So why don't we start out with taking a quick look at Senate Bill 1160. This is the bill that grabbed all the headlines in 2016. And as you can see here, the most popular pieces of this bill are that it automatically stays any lien once that provider has been charged with fraud. And that is a key word, charged with fraud. And so basically, if you do have a provider who has been charged and those charges are pending and they are not convicted or they haven't gotten a not guilty verdict back yet, then that lien should be automatically stayed. And the reason why I bring that up is that's different than a lien claimant or a provider who has been convicted of fraud. Let me see, AB 1244, that bill deals with that. And we will touch on that a little bit later. Just to sum it up very quickly, if you do have a lien claimant who is convicted of fraud, the state needs to issue a notice of suspension to suspend that lien claimant, A, from treating injured workers, and B, from pursuing, basically from billing for anything after the date of their suspension. We are going to talk about those regs a little bit more, which detail how those suspensions work. But let's take a look at another bullet point under Senate Bill 1160. This bill also requires lien claimants to file quite a few, well, it requires lien claimants to file a variety of declarations. For example, a provider may have to declare that they are the PTP. That's one of the many declarations that they can choose. Don't worry, we will list all the declarations that lien claimants have an option to choose later on in this presentation. So you'll get to see all of them. Thirdly, Senate Bill 1160 bars utilization review during the first 30 days, effective January 1st, 2018. There are quite a few exceptions to that rule. So for example, one of the exceptions is surgery or MRIs. Those would still go through UR. Again, don't worry, we will go through those exceptions later on in the presentation as well. So Senate Bill 1160, as noted in the prior slide, this bill automatically stays any lien once that provider has been charged with fraud. The DWC created some very basic rules and regs that were approved by the Office of Administrative Law last week. And so in short, these were passed as emergency regs, and they detail what exactly a suspension is and some of the finer points of that. That being said, Alec, I know you and I were talking about this. We both felt that these were kind of bare bones regs. Later on this year, the DWC is supposed to draft new regs, and so they may get a little bit more detailed in how they can suspend providers.
Yeah, and to add on to that, I think one of the big issues we're going to be seeing coming up is the emergency regs essentially state that the providers that are convicted can no longer submit bills essentially from the date of the conviction. There's a real question as to whether or not that's going to apply retroactively to bills sent prior to the date where they're suspended. So I believe that's still up in the air, and that's probably going to be a major source of litigation that's going to have to be clarified.
Excellent point, Alec. And now, as mentioned earlier, Senate Bill 1160, it does go in hand with these two other bills, Assembly Bill 2503 and Assembly Bill 1244. Like Alec was saying, Assembly Bill 1244 deals with the suspension of physicians who are convicted of fraud. Now, let's just take a look at the declarations that lien claimants have to sign under Senate Bill 1160. So first of all, any new liens that are filed after January 1st of this year, they have to have a declaration. What if you have a lien that was filed before January 1st this year? Well, if you have an older lien, that lien has until July 1st, 2017 to file a declaration. What happens if they don't file one of these declarations? They are dismissed. Basically, they're automatically dismissed, but we've been reading that. And one of the great things about these declarations is that many people believe that these declarations are setting up the fraudulent providers for perjury charges down the road. And so these declarations are going to, basically they're aimed at helping the district attorneys when they do prosecute fraudulent lien claimants. So let's take a look at some of the things that these lien claimants must declare. First of all, a lien claimant must declare that their lien dispute is not subject to IBR or IMR. And this is important because I think all of us can name at least a few lien claimants who really hate going to IBR. I know of some who just, they don't want to pay the fee, they're scared of what IBR is going to do, and they really want to just stay away from IBR at all possible costs. Now after that, lien claimants can pick any one of this list of lien declarations. So for example, they could say that they're a treater in the MPN, or maybe they're providing med legals as the AME or QME. A third type of declaration is that they provided treatment that you, the claims adjuster, authorized. Fourth one is that they made a diligent search and could not find an MPN. Another option is that they documented that the claims adjuster neglected or unreasonably refused care, and we suspect that's going to be a popular one among the lien claimants. One other option is that the medical treatment was needed because of an emergency. And then we have several options at the end. So for example, a lien claimant is a certified interpreter who provided services during a med legal evaluation. Or the lien claimant is a copy service providing med legal services. And then lastly, a lien claimant has an expense allowed as a lien under DWC rules and regs. So once again, the lien claimants can pick any one of these declarations. Now, one of the reasons why the lien claimants hate these declarations is that many of the existing liens are going to miss that July 1st, 2017 deadline. Once again, the lien claimants who have that July 1st, 2017 deadline, those are your older liens filed before January 1st of this year. Secondly, lien claimants hate these declarations because it makes them state something under penalty of perjury and put their name on it. And it creates a catch-22, which we'll describe on this slide. So for example, let's say that you are a non-physician lien claimant, and you have to sign one of these declarations because you want to file your lien. Well, how is a non-physician lien claimant going to file a declaration under penalty of perjury when they don't have legal access to medical records? And please remember that these non-physician lien claimants are not entitled to medical records absent a judicial order. So many of these non-physician lien claimants, they forget or sometimes just kind of lazy about filing their petitions to get medical records from the claims adjuster or the defense attorney. And these lien claimants, they still have to abide by the statute of limitations. So what you're going to find yourself with is some liens are going to find themselves up against that 18-month statute of limitations. They don't have any medical records to support that declaration, and they'll just file a declaration anyway, despite having no evidence to back that up. This sets them up for perjury. And so that being said, we are anticipating that many of these lien claimants will be filing declarations which are false. And here are some of the examples. Some will falsely state that they've made a diligent MPN search. Others are going to basically give a false statement about whether a MPN exists at all. Some are going to try and say that they're the PTP, and that is one thing that came up when we were recently presenting this, is that basically we do anticipate that some lien claimants may argue that they were the PTP when in fact they weren't, and so that may lead to some extra litigation.
Yeah, you're going to want to look for your election letters. That's going to be a big deal. And I think with all of these sort of catch-all ones, we're going to have some issues on litigating what the nature and extent of things like a diligent MPN search is. Simply going into Google and typing the MPN for the carrier is probably not going to be considered a diligent MPN search, but I'm sure there's going to be litigation on exactly what that means.
Very true, and yeah, to Alex's point, for example, yesterday I just had someone on the applicant side go to the MPN page and then click on the wrong link, and then tell us that my MPN information is wrong, yet they aren't using the website correctly. So that is definitely an issue that will come up in the future. Now, some lien claimants are claiming that there is emergency treatment that they provided and that it was necessary in that type of factual scenario. That may be something where your documentation and also your witness testimony may come in handy. And lastly, as we stated earlier, we do anticipate that many of these lien claimants are going to falsely state that there was a denial or neglect on the defense, on the part of the defense. Now, here's what some of the lien claimants are saying about Senate Bill 1160. CSIMS calls it Senate Bill 863 Light, and they have accused the DIR of trying to extinguish as many liens as possible. One lien rep told me that she is going back to the defense side because of the catch-22 that we mentioned above. Many of these lien claimants are not going to have the evidence to back up that declaration, and in short, the work comp defense, we can hammer them. And so this particular lien rep that I was talking to, she got that idea from a lien claimant manager who also views these declarations as problematic. And so in short, it's not just one or two lien reps who are saying that these are going to be a problem. It's people at the management level and people at the lobbying groups as well.
Oh, and they're very well aware of it. As soon as this passed, I know a lot of the lien reps and their management were very upset with it. They were basically claiming it's going to put them out of business. So this is definitely an issue, and I think we're going to see the number of liens start dwindling very shortly.
That being said, with that in mind, for example, you may have some lien claimants who are charged with fraud, and they may very well be considering a guilty plea. That being said, with these people potentially going out of business, or at least with their main source of income being in jeopardy, one thing I did want to warn you about, and one of the chief counsels from one of our clients mentioned the other day, if someone is charged with fraud, we don't recommend putting into a letter to that lien claimant saying that they are a fraudulent provider or saying that they've been convicted. So it is one thing you want to be very careful about, because these people are not going to have income, and as we've seen with some lien claimants, they have filed defamation lawsuits. So that's something you don't want to put into print. Basically, if you aren't sure of it, don't put that into a letter to a lien claimant or into a legal pleading. So yeah, I just wanted to warn you about that, as that's a very easy mishap to make. And so one way you can kind of verify that is keep an eye on Work Comp Central and the other publications as well. One of the things that all those publications are very good about doing is noting who's indicted and who is convicted. Work Comp Central often links to the indictments themselves. And for example, they were very good about noting that Dr. Sobel had pleaded guilty to his charges. And so anyway, that's one way that you can confirm that this person is convicted or that this person is charged. Again, if you aren't sure, lean on the side of caution. So let's move on to a different element of Senate Bill 1160. One thing it does is for liens after January 1st of this year, this bill would also invalidate any assignment of a lien made in violation of Labor Code 4903.8. Now, just a brief reminder, Labor Code 4903.8 is the latest anti-assignment statute from Senate Bill 863, and it bars specific types of assignments filed on or after January 1st, 2013. Now, one other thing, the one type of assignment that is still allowed is if the person has stopped doing business and that in their capacity as a provider, as a doctor, etc. So when that happens, they are allowed to assign that lien over. Now, a different element of Senate Bill 1160 is that it changes UR starting January 1st, 2018. And it bars UR during the first 30 days of a work injury for most treatments provided by MPN doctors. Now, there are exceptions to this rule. Again, there's surgery, hospitalization, psych treatment, DME, home health care, MRIs, and CT scans. So all those things are still subject to UR. And I believe that we're going to get some regs clarifying those exceptions and maybe giving us even more exceptions down the road. Now, this is an interesting element of Senate Bill 1160. It allows the AD, the Administrative Director at the DWC, to create a Labor Code 5710 fee schedule. And basically, they must come up with a range for these 5710 fees before July 1st, 2018. And I'm pretty sure that the way they're going to do it is they're going to base it on the years of experience of the attorney who went to the deposition. And that's great, because we had one depo this summer where the applicant's attorney passed the bar in June, showed up to the depo in July, and then applicant's attorney's office billed us $450 an hour for an applicant's attorney who really couldn't even talk about the case in chief at the deposition and didn't have, wouldn't even consider settling the case. So yeah, that being said, we don't want, we definitely are always going to object in those scenarios. When you have someone who really lacks the experience and they're billing a really high amount per hour. And so one thing to keep an eye out for, once the Administrative Director does come up with a proposed fee schedule, we do anticipate that CAW is going to fight about the monetary amounts per year of experience. So yeah, we do definitely anticipate a fight down the road once the DWC issues this proposed fee schedule. And just some other quick bullet points about Senate Bill 1160. It requires the DWC to create rules and regs for the identity and credentials of interpreters. It also allows the DWC to make new additional requirements to treaters reports. So your PR2s may have a few extra categories if the DWC decides that those are important. This third bullet point, I'm pretty sure that most of your systems as far as data reporting are automated, but you do want to make sure that you are reporting data correctly, because if you aren't, the fine is increasing this year from $5,000 to $10,000 for adjusters who fail to comply with data reporting requirements. So please make sure that those automated systems are working. That being said, if they are working, I don't think you have anything to worry about. But with the fines being so large, we definitely wanted to bring that to your attention. One other element of that I should note is that claims adjusters who frequently are failing to comply with these data reporting requirements could find their names on a DWC blacklist. Senate Bill 1160 definitely mentioned that. So yeah, you don't want to wind up on their naughty list. Now, 1160 also allows the administrative director to update the MTUS by order. And that would not be subject to the APA, the Administrative Procedure Act. That act is the one that requires public comment every time the DWC passes a rule. So this is great. And the reason why is that if a study comes out this week from Harvard University with some findings that would be very, very applicable to work comp, the administrative director could plug those into the MTUS next week, issue an order, and bam, it's in. No several months of comment, no fighting about it. They can just quickly update the MTUS, so that's great. So just to recap here, Senate Bill 1160, we have our declaration versus dismissal traps. It creates these declarations that trap unsavvy lien claimants, and that is effective in 2017. It also automatically stays any lien once that provider has been charged with fraud. Oh, and one thing I should point out in regard to that is if you go on EAMS and you do a lien search, I'm sure many of you have noticed that the word stay is next to certain lien claimants' names. Yep, you guessed it, that lien claimant is automatically stayed, and the DWC has been nice enough to update the ones they know about on EAMS. Alec, on that point, one thing I was hoping you could tell our listeners about is what you've been seeing with the list at the San Diego board and some of the other boards.
Yeah, so I've been speaking with Presiding Judge Levy a bit about this, and currently there are kind of a lot of issues up in the air. The DEU, I think it's the DWC Medical Unit actually, is working with EAMS. Going forward, what they're attempting to do is take all these providers that are charged and flag those liens, at which point they'll issue something in EAMS that indicates essentially an automatic stay, and possibly with a letter going out like you would get a notice of hearing indicating essentially that this provider has been charged with some sort of criminal activity. They haven't defined the actual nature and extent of the criminal activity yet as to what is or what is not going to be in that group, other than some basics: a felony conviction, a conviction with basically some sort of fraud present, defrauding either Medicare or the workers' comp system or Medicaid, the state system. That's still a little bit up in the air, and exactly how that trickles down to, say, current other providers, like, say, the doctor themselves are charged with something. There's a question as to whether or not this would stay proceedings on things like durable medical equipment, medications, and other ancillary services which are provided possibly in good faith to the doctor before anybody realizes that the doctor's committed some sort of fraud. So going forward, that's the case. Currently, my understanding is there have been something like 200,000 or 300,000 liens that have been flagged for this, and the board is still working through that. In the interim, I know San Diego hasn't done this yet as of the last time I was there, but some other boards are listing the providers that are automatically going to be put on that stay list while the medical unit is going back through and flagging all these liens. So they're asking for our research and our help to essentially bring in, something, a newspaper article would be good, an actual accusation or indictment or some other sort of documents from a prosecutor would be better to show that the lien should be stayed. Once again, there's a question whether or not those are bifurcated in the end, and we can try some of these but not the others, or if they just stay the whole thing pending the outcome. To add to that, they're still not even absolutely sure. There's going to be some sort of special lien unit or special lien court set up to litigate these issues, and they're not sure if it's going to be a few designated boards, kind of like you have up in LA where they kick it all over to one board to litigate liens after the case in chief is resolved, if it's going to be one for Northern California and Southern California, or if they're going to be appointing, say, maybe a specific judge at each board to resolve these special lien unit issues. They're not entirely certain how that's going to work. So we're a few steps away from getting this program streamlined. I would assume at least 7 or 8 months just to get the actual courts set up to start processing these liens themselves. So yeah, anything you'd like to add to that, John?
Yeah, basically to Alec's point, one of the things I read in Senate Bill 1160 is that, in short, when you have lien claimants who are convicted of fraud, what's going to happen is the administrative director is going to send them over to the chief judge at the WCAB. And so, yeah, like Alec was saying, it's really up to the chief judge's prerogative and the appeals board's prerogative as far as how they want to set that up. I think we will see some kind of indication as far as which way they're going to go in the next few months. But in these first few weeks of the year, we just haven't heard that from them yet. But that being said, I really would be surprised if they took more than 60 days to tell everybody how they're going to approach that. Okay, and just to move on to our final recap of Senate Bill 1160, again, it bars UR during the first 30 days for basic care. That's effective January 1st of next year, so you don't have to worry about that just yet. Labor Code 5710 fee schedule should be on the way. There could be some new interpreter requirements. And adjusters, please comply with your data reporting as the fines are increasing. Now let's take a look at 1160's buddies, Assembly Bill 2503 and Assembly Bill 1244. These both supplement Senate Bill 1160. 1244 is the one we've mentioned a few times already. Keyword here is convicted. This is the one that suspends physicians from practicing in work comp once they are convicted of a felony. And as Alec touched on earlier, what's going to happen, basically this process was just described in the regs that were approved last week. And in short, the DWC is going to send out a notice of intent to suspend a physician. That physician has 10 calendar days to object. I double check that date real quick. But in short, they can object to the NOI. If they do object, then a hearing has to occur within 30 days as to whether that provider should be suspended or not. Now, these new rules and regs define what that hearing is going to be like. For example, one of the things that I saw in there is that the rules and regs limit the amount of testimony or the type of testimony. So, for example, you aren't going to have testimony over the course of 25 days in these hearings. I think they're going to go pretty quick. And so anyway, one thing I've been keeping an eye out personally for is for these doctors who we know are convicted, whether the DWC has issued notices of intent to suspend just yet. And there was a particular doctor, Dr. Sobel, who, as you know, pled guilty, yet I have not seen any word of a notice of intent to suspend him yet. So anyway, that's something we're keeping an eye on. I believe the DWC will have stuff like that on the website down the road, but once again, I think it's just so early in the year that they're still taking time to do that and update their website. And so as noted earlier, AB 1244 calls for the Division of Work Comp to flag doctors convicted of felonies. And it also requires them to suspend these felonious doctors from practicing. And so they're issuing these notices of suspension. The bill also calls for the suspension of providers convicted of Medicare and Medicaid fraud. So even though that type of fraud may be unrelated to work comp, it can still get those providers in trouble. And then once the DWC flags these providers, they are supposed to notify the applicable state board. So for example, the State Medical Board of California would be notified by the DWC when someone is flagged. As Alec noted earlier, Assembly Bill 1244 calls for special lien proceedings, which again means that the DWC must notify the chief judge about the offender's actions, felony or misdemeanor, and enact these special lien proceedings. So what are special lien proceedings? Well, these proceedings mean that carriers get to enjoy a presumption that the lien is connected to criminal or fraudulent activity. And it places the burden of proof on the lien claimant to rebut that by a preponderance of the evidence. So 51%, that's what preponderance of the evidence means. And so, yeah, that lien claimant has to show that their services were not connected to the fraud or the criminal activity. Moving on to another one of 1160's buddies, Assembly Bill 2503. This bill calls for RFAs to go directly to the claims adjuster. And the reason why this bill came up is that a ortho group lobbied for this bill, citing confusion about where to send RFAs that need to go to UR. So this bill makes it very simple. Send them to the adjuster. And this one took effect on January 1st of this year. As I understand it, many of your offices have already implemented and streamlined procedures to make sure that these RFAs are not getting lost on the way to UR. One thing we recently talked about at a presentation a little while ago is what happens if the lien claimant sends it to an adjuster who's on vacation, or an adjuster who no longer works there, or sends it to the right TPA but to the wrong adjuster. So those are questions which could lead to extra litigation down the road, and those are probably going to turn on the facts of each individual case. You know, what did the lien claimant, what did the provider do? Who did they send it to? Where was the person that they sent it to? Where was the claim adjuster? And so on. So those could be very factual driven, but those could lead to some conflicts down the road. Moving on to Senate Bill 482. This is another bill that was signed by Governor Brown last September. And this bill calls for doctors to check the cures database before prescribing drugs on these various schedules. So what types of drugs are on these schedules? OxyContin, Percocet, Dilaudid, Fentanyl, Klonopin, Valium, Ativan, and Soma. Basically anything you don't want to drive on. And pharmacists and vets are exempt from this bill. So yeah, this is not going to apply to pharmacists. Now, what is the cures database? It is a California database that tracks dispensing data, and it's limited to these groups: licensed MDs, licensed pharmacists, law enforcement, and regulators, aka the DWC and the DIR. Now, what if the doctor dispenses these drugs without checking that cures database first? Well, someone could report those doctors to the Medical Board of California. The only problem is that this bill did not say who is supposed to do the reporting. I guess with it being vague, it could mean you and me could be reporting them to the Medical Board of California. Now, one of the issues that I did spot on this bill is it doesn't really say who's going to actually make sure that doctors are checking the cures database before prescribing drugs on schedules 2, 3, and 4. And without any monitoring by regulators, basically the most reckless doctors are likely to continue ignoring the cures database and are going to keep on prescribing. So yeah, that's a problem. And with that problem existing, this bill may be kind of feckless. Now, one of the one way the state might be monitoring it, and we may just not know about it yet, is they could be checking which IP addresses are pinging that cures database. Now, if they are keeping track of that, then maybe they do actually know which doctors are checking the cures database on a daily basis and which ones aren't. So for example, if Dr. Killjoy's IP address is not pinging the cures database every day of the week, but Dr. Killjoy is prescribing drugs on schedules 2 through 4 every day of the week, then yeah, that's an obvious problem. So maybe the state is monitoring their IP addresses. That being said, I haven't seen any evidence yet to suggest that. Now let's move on to Assembly Bill 2883. This bill deals with directors and officers who are exempted from work comp coverage. And this bill says that directors and officers must own 15% of a corporation's stock before they're exempted from coverage. It also applies to general partners of partnerships and managers of LLCs. Now, for your partners and managers, those folks must specify in writing that they are waiving said coverage. And without that, the exemption does not apply. Now, the whole reason why they passed this bill is kind of curious. Some employers were trying to avoid coverage for employees who should, in fact, have been covered. And in the past, some employers have waived coverage for employees without actually ever telling that employee. And one of the lobbyists brought up this example. There was a restaurant who reportedly named a kitchen employee the vice president of dishwashing to keep premiums low. And, well, I'm sure that guy was an excellent dishwasher. He probably was not an actual VP of the company. So this bill, in hindsight, it really makes sense to pass this. In short, to keep people from naming their dishwasher as a vice president of the company when they're still getting paid $10 an hour. Now, AB 2710, this bill specifies how carriers may charge employers for SEIGA assessments. And it says the carriers must bill employers for assessments that are paid to SEIGA the year after the assessment was paid to SEIGA. And so what this does is this bars carriers from charging employers for SEIGA assessments that occurred years ago. Now, what happens if the carrier has overcharged the employer? In other words, they've charged higher than the actual assessment. That extra money that the carrier got from the employer must go to SEIGA as well. So, in short, 2710 protects SEIGA. Now, one other thing that came up in November of this year is that California voters approved recreational marijuana. As many of you know, California law bars employers from having to reimburse injured workers for marijuana. And many employers' HR departments, if they're smart, they've been bringing this up in their annual meetings and telling their employees, hey, don't smoke pot before coming to work. One of my friends works at a large aerospace contractor, and he had a 5-star general telling their office that. Obviously, no one suspects the general of using recreational pot. So one thing that is important, though, that comes up with this is you may have more workers showing up to work intoxicated. And CWCI wrote a great white paper, that's the California Workers' Compensation Institute, and the main point of this white paper was that while we still have the intoxication defense, it can be difficult to prove. And the reason why this defense is difficult to prove is that, in short, the defense has the burden of proof in California. Marijuana stays in the bloodstream for much longer than alcohol. And because of this fact, no objective tools to prove intoxication at a specific time at the time of injury. Yeah, so there is no objective test to prove that at 3:30 p.m. that the grocery store employee was intoxicated while sweeping the floor. And that makes it very difficult to prove that marijuana was the proximate cause of the incident that occurred while that employee was sweeping the floor. So how do you counter that?
Yeah, I mean, I'm sure any of you guys that have had the intoxication defense realize even with a drug like alcohol, where it's pretty easy to test for it, it's very hard to prove the proximate cause for the injury in a lot of cases. In fact, often we think we have a very good defense because they go into the doctor and they test positive for some sort of drug, or alcohol, and it turns out that the judge says that you haven't proven that that was the proximate cause of the injury. Maybe they use these drugs all the time. So you can't say that on this particular day that it was the cause and not the actual accident itself was the cause. I know this is always a problem that comes up. And I think with marijuana staying in your system for, I believe it's something like 30 days, it's going to be very hard because I think the employee would always say something like, oh, I used it a week earlier. And you'd have a very hard time putting out the specific date for that.
And yeah, to Alex's point, one way you can kind of prove, or one way to help solve that problem is to touch base with your witnesses who were there at the time. Now, if you have 4 witnesses testifying that that employee was acting strangely, was in the car for an hour before coming back to work and smelled like green thumb, then yeah, that will help your case much more. But even then, it still may be an uphill battle. So yeah, we just wanted to bring that to your attention, that even though that defense does seem like a great defense, it's not always the slam dunk that we think it is. Now let's take a look at some of the savings from Senate Bill 863. The WCRB estimates, or they estimated that $1.4 billion in savings occurred on a yearly basis due to this bill. Now that's really a lot higher than last year's prediction for $500 million of savings a year. So where's all this extra money and savings coming from? Well, $400 million of that is coming from RVS adjustments to the fee schedule. And then another $400 million is coming from decreasing medical severity. So that's good. Our claims are basically the injuries aren't as bad. Well, actually, I'm mischaracterizing that a bit. The medical bills are not as bad. That's what medical severity means. And so the WCRB also tells us that lien filings are down again. They peaked at 108,000 in the first quarter of 2016, and they're down to 76,500 in the third quarter of 2016. Now, after 2012, med legal and interpreter liens have also decreased, and the WCRB tells us that most liens are medical providers now, in fact, 85%. So that is good news. Some other news from the WCRB tells us that, well, everyone initially thought that IMR would reduce TD duration. It turns out not to be true. IMR is unrelated to the duration of TD. Here are some other stats for you. Indemnity claims increased by 2.2% from 2013 to 2014. They decreased a little bit, 0.2% the next year from 2014 to 2015. And then they increased again during the last 6 months of 2015. And there's also a new study from the WCRB, which came out in late November, around Thanksgiving time, which confirmed these trends as well. So you may want to go on their website and check them out for that. Now, Senate Bill 863 did call for 3 new fee schedules. We'll just go over those very briefly. The home care fee schedule, that's still proposed. Interpreter fee schedule, that's still proposed. And then the copy service fee schedule, as most of you know, that was approved last year. Let's start with the home care fee schedule. This one is still under construction, and our most recent proposal came out, about 6-7 months ago, May 2016. So the DWC, what they can do is they can either take that latest proposal and push it into final rulemaking and try and finalize it, or they can make more changes and put those up for public comment. And that fee schedule is based on Medi-Cal and federal work comp fee schedules. And the latest home care fee schedule increased reimbursement rates for providers by 5.8%. And these rates for skilled providers are based on a formula. I believe that's a Medicare formula. And so this most recent proposal, it also removed the use of CMS's OASIS system. Now, why is that important? Well, one call, as many of you know, they help carriers with provider issues. One call objected to the removal of OASIS from the home care fee schedule because this OASIS system, this federal system, it requires an initial assessment by a registered nurse, which is pretty standard. You know, you do want a registered nurse going to the home of the injured worker and verifying what services they actually need and don't need. That is a great cost control for carriers, whether you're in work comp or group health. And if Medicare thinks that that's important, then that should be in work comp as well. So I'm glad that one call objected to the removal of that, and I hope the DWC puts that back in. This most recent proposal, it also specified that home health care providers, so the nurse that is going to the applicant's home, does not become the employee of the carrier or the TPA. That's important because that prevents the nurse or the applicant's sibling or relative who is providing the care from getting injured and filing a new claim against the carrier or the TPA. And that was one thing that carrier and employer lobbyists did bring up. It wasn't in the first version, but the DWC listened to them and they plugged that into the most recent version. Now, one element that CA objected to is that the latest proposal did not include a provision that would pay providers for travel time to and from the applicant's home. So CA had objected to that. They want to see a provision like that. Lastly, the home care fee schedule. This most recent proposal states that unskilled home health care workers cannot get paid less than minimum wage. When in doubt, if you have a state minimum wage, but it differs from your local minimum wage, you have to go with the higher of the two. Let's move on to the interpreter fee schedule. This one is also still in the proposed stages. And the reason why is that when the most recent proposal came out in 2015, it was so strongly opposed by interpreters that it had more than 400 comments. And most of those comments were from angry interpreters, but some were also from the defense bar as well. Now, what needs to happen with this is the DWC does need to issue a new revised version of a proposed interpreter fee schedule, which will again be subject to comment. And when that new proposal comes out, be prepared for lots of fighting. One thing I should note about that is that proposal which came out in 2015, that would tweak the minimum number of hours that an interpreter could bill for down from 2 hours to 1 hour. So currently, an interpreter is billing a minimum of 2 hours at a rate of $45 per hour. Under this most recent proposal, their minimum would drop down to 1 hour, and they would recoup about $52.50, if I remember correctly. Why is that important? Well, you may see your standard $90 data service drop down to $52.50. Obviously, that would save carriers quite a bit of money. And yeah, I hope that they hang on to that provision going forward. One other thing that was interesting that the defense bar brought up, they wanted to see this added to the interpreter fee schedule. And that is, they wanted some kind of control for the interpreters who are at the board and basically bill on 20 to 30 cases a day, allegedly working on each case for 3 hours a day. Well, obviously that interpreter did not work 60 hours in a day. That would be impossible. So there were lobbyists on the carrier side who want to see some kind of control for that, your interpreters at the board. Now, as everyone knows, the copy service fee schedule was approved and it became active for all dates of service on or after July 1st, 2015. One quick way to remember this is just think $180 for most services. The flat fee of $180 covers records 500 pages or less. Every page exceeding that 500-page threshold costs 10 cents a page. Here are the things that copy service bills must include: photocopier numbers, claim numbers, billing codes, and their tax ID number. And here's how much extra copy costs: $5 if you ask for it quickly within a month. If you wait more than a month, then that extra copy of records costs $30. DWC transcripts are more expensive, $100 for 33 pages or less, and it's an extra $3 a page for anything more than the 33 pages. And absent showing a or absent a showing of good cause by the copy service, you payers are not liable for records previously obtained by subpoena or authorization by the same party and served from the same source. So just to give you a quick example, if applicant's attorney has subpoenaed the same provider 6 times, you would only be liable for the first time unless the copy service can show that there was good cause for the extra 5 subpoenas. Now, one thing I did want to remind everyone about, because it is a big deal, it'll save carriers a lot of money, and that is the formulary. This takes effect on July 1st, 2017. And the DWC opted to go with the ACOM formulary. And in short, this formulary, it creates 2 lists of drugs. You have one list of preferred drugs like ibuprofen. Those preferred drugs do not require a UR. Now, your non-preferred drugs like OxyContin, those will require a UR. So what about combinations of drugs from both categories? Well, a few of those will be dispensed on a, quote, first fill basis, end quote. And what that means is for example, one popular drug that's prescribed at the start of May claims is a combo of hydrocodone and acetaminophen. Now that would fall under the first fill basis category. And basically, that prescription could be filled within the first 7 days after an injury, and that prescription would be limited to a 4-day supply. After that, it's subject to UR because it contains a non-preferred drug. So just to recap here, every bill we've talked about so far has become law. Of the regulations we discussed, the home care fee schedule and the interpreter fee schedule are still just proposals. Same thing with the formulary, just a proposal, even though the formulary must be implemented by July 1st. Now, the copy service fee schedule, that one is finalized, and that is the law. And it looks like we're running out of time a little bit, so I'll try and speed things up. But that being said, every bill after this point in this presentation are bills that either did not make it and are not law. So here's a list of bills that were proposed but either vetoed or killed during the 2016 legislative session. Senate Bill 897, Assembly Bill 2086, and Assembly Bill 1643. And the reason why we're going over these bills, pardon me while there's an ambulance driving in the background. Let them pass by there. And so one reason why I picked these 3 bills to go over is that I think we're going to see similar versions of these in the future. So let's start with 897, Senate Bill 897. This bill would have allowed first responders who suffer a catastrophic injury, such as an amputation, shooting, severe injury, to collect up to 2 years of salary continuation pay instead of temporary disability. Currently, these same first responders can only get 1 year of that. For those of you who don't know, salary continuation pay is 67% of pre-injury wages. Now that being said, expect CAW and the unions to push for a similar bill next year. Again, this bill was vetoed. Another bill that came up this year, second year in a row actually, this one, Assembly Bill 2086, would have given neuropsychologists their own QME designation within the medical unit. Now, the Division of Workers' Comp eliminated that category, the neuropsych category, in 2015. And lawmakers tried to remedy that by passing a similar bill in 2015, which would have given the neuropsychs their own QME category again. But that 2015 bill was vetoed by the governor. So in 2016, they gave it another shot. And this 2016 version of the bill tried to say that only neuropsychologists who have been used as AMEs 5 times could act as neuropsych QMEs. That being said, that still wasn't enough to avoid the veto stamp of the governor. And with that, I expect a similar bill to come forward in 2017 trying to give neuropsychologists their own QME designation. So keep an eye out for that next year. Traditionally, this bill has had very strong support among the Assembly and the Senate. But that being said, the buck stops at the governor's desk, and he has been vetoing this one. Now, here's another bill which has come up in back-to-back years. Assembly Bill 1643 would have increased the maximum permanent disability rating for a mastectomy from 5% PD to 16% PD. The reasoning behind this bill is that lawmakers looked at the fact that under the PDRS, a man's prostate is worth 16% permanent disability. CAW wants a woman's breast to be worth the same amount of PD as a man's prostate, so therefore they want a mastectomy to be increased from 5% to 16% PD. Now, one of the important parts of this bill is that it would have barred apportionment to pregnancy, menopause, carpal tunnel syndrome, or osteoporosis. And frankly, I think that would have come up quite a bit more often than the PD element of this bill. So this bill was vetoed in 2015, and another iteration of it was vetoed in 2016. So that being said, expect a similar bill to come up in 2017 that especially will most likely seek to bar apportionment to the items mentioned here. And last but not least, during the November 8th election, Californians did approve Prop 54. And this GOP-backed proposition requires bills to be in print 72 hours before final floor voting in either house, the Assembly or the Senate. And how does this affect us? Well, as you may have noticed, our last three giant bills, Senate Bill 899, Senate Bill 863, and Senate Bill 1160, these were all hotly negotiated down to the wire and had very many last-minute changes. So that being said, Prop 54 is going to make it quite a bit clearer as far as what our lawmakers are doing to our work comp bills in the final days of the legislative session. So basically expect, that is something you'll probably want to check in mid to late August, because I expect that we will see more bills being printed on the legislature's website that time of year. So again, that's usually mid to late August, with the filing deadline being late August.
Okay, and just real quickly, I'd like to go over some of these themes we're discussing with regards to the lien issues. So basically, our general recommendation right now is if the provider is charged with fraud, go ahead and let the judge know and seek a stay. It's still not entirely clear as to whether these ancillary services that are prescribed by the doctor, referrals out to other doctors, etc., are going to fall into that category. But just generally speaking, the judges don't really like having lien trials in the first place, and having to bifurcate and having two lien trials on the same case is, I believe, going to be very unlikely. So my recommendation in most circumstances is going to be seeking a stay on all liens. However, I did speak with Presiding Judge Levy, and he indicated that if during this stay period while the providers are charged, as you know, it can take a long time for these criminal cases to go through the system, and then we would have to get back on the docket and go through our system, they will approve settlements for us. This is a good way to negotiate a cheap settlement in most cases. Generally speaking, if a prosecutor is going to be charging someone with serious offenses like this, they've got a fair amount of evidence and they think they have a very good chance of prevailing, or else they wouldn't be bringing these accusations forward. So if you do want to settle, you can probably do it cheaply and quickly. However, I would caution you that in cases where it's likely that there is fraud involved, you could be just replenishing the funds for a criminal defense attorney for some of these people. So that being said, if you do want to settle it quickly, it's not a bad way to do it. We don't have a lot of these details worked out yet. You can feel free to contact either one of us, and we'll give you the latest updates. It's sort of a hot button issue at the board right now. As we mentioned earlier, a lot of lien claimants, or a lot of lien reps, are looking to get out of representing lien claimants, going as either applicants hearing reps or attempting to go as defendants hearing reps. They can kind of see that it looks like a lot of these sort of more rampant abuses are being cracked down on harder, and hopefully this new legislation will clean up on a lot of the bills. Although I'm sure, as you all realize, there's always unintended consequences with new legislation, and there will always be people seeking a way around it. So we'll see how that goes.
And yeah, that is an excellent point, Alec. Yeah, one thing I've seen from covering legislation in all 50 states is, as many of you suspect, our lawmakers don't always read these bills before voting on them. Sometimes the language has small flaws, which turn out to be very important later on. So there may be a few of those, as Senate Bill 1160, for example. I think that was around 20,000 words. So yeah, with things being hastily thrown together, there can often be unintended consequences which create litigation in the future. Okay, and well, it looks like we're just about out of time. I do see that some of you did send us some questions and some rather funny comments, so thank you very much. And yeah, I will try and send you back some answers afterwards here. But yeah, it does look like we're out of time. So thank you again so much for joining us. Feel free to contact Alec, myself, via phone, email, whatever, or anyone else on the Bradford Barthel team. And yeah, we'll be happy to help you, especially as we see more rules and regs and legislation going forward. So thank you so much for your time, and Happy New Year.